Members, let's reconvene. Ms. Claudia Mo, second round, 3 minutes. Please switch on the microphone for Ms. Mo. In clause 5, brackets 4, in this section, official recording in relation to the national anthem means a recording of the anthem provided for the purposes of this section on the website of the government. The Chinese rendition is very clear, but the English text is rather peculiar.
Means a recording,咁啊都係一套啦嚇 of the national anthem provided for the purposes 係眾數 of this section on the.
So the word purposes in English is in the plural form. So for the word purposes, why is the plural form used? You have been talking about playing and saying. So are you using the plural form because you refer to both singing and playing? But all along you have mentioned playing and saying in the same breath. So what other purposes are you referring to? In the Chinese version, you did not say anything about the concept of purposes. And then you mentioned a website of the government. In other words, there's a single website, but the Chinese text simply says 政府網站. To me, the government has many different websites for many different departments. Even the chief executive has a Facebook page. So why do you use the plural on some occasions and the singular in others? Mr. Pang, thank you very much for the question. In the phrase "for the purposes of this section," it refers to the sake of this section. So the purposes refer to this section. You are correct. Purposes might mean intents, but for the purposes of this section refers specifically to this section. In English, there's an indefinite article, but in the Chinese, there is no such concept. I understand that the Chinese would not say, would not use the plural form when it talks about government websites, but for the English version, you should say website brackets S. In other words, there could be multiple websites. Are you referring to the website of the Information Services Department? It is the website of the Constitutional and Mainland Affairs Bureau, so I'm confused. I assume that the government website refers to the ISD website, when in fact you are referring to the CMAB website. Dr. Chen Zhongtai, second round, 3 minutes. I want to pursue the conditions for the playing and singing of the anthem at LegCo. Some people are concerned that when the anthem is played and sung, well, I would not talk about, I would not say it is a freedom of speech, but there are some concerns for the LegCo members. So if the bill is passed and that the anthem will have to be played and sung, would the national flag and SAR flag be hoisted? If that's the case, you have to explain the matter to the public. In the past, in terms of the dress code at LegCo, the ROP committee discussed they agree that the presence of a collar or the words printed on the shirt, such as Che Guevara, would not be considered. But in terms of standing solemnly and acting with dignity, when the anthem is played and sung, the clothing of electrical members might be governed. So the government should explain the issue. Or should I put it this way? In the past, there was no liability over what we wear within electrical, but in the future, when the anthem is played and sung within the electrical complex, the clothes worn by electrical members might be governed. I answered this question earlier. In terms of the etiquette for singing and playing the national anthem, there is no criminal liability. Dr. Chang asked about the attire of electrical members when the anthem is played and sung. It is not simply governed by the rules of procedure. So the person presiding over the oath taking would make a decision. He or she would refer to Article 104 of the Basic Law as well as the provisions in the Oath and Declarations Ordinance. I have a follow-up question. I will ask my question later. Mr. Charles Mock, third round. So for the Central Music Academy, when will it furnish us with the details or information? So this could be passed very soon, and like the permanent secretary said, if the bill is passed and some provisions are found to be not enforceable, would there be any contingency plans or remedial measures? For example, some of the provisions might be postponed. You talked about a website under your bureau. Is there a need to clarify the issue properly? The English version says a website of the government. It is not specific. You did not even refer to a specific website of the government. So if somehow another government department uploads a score, there could be confusion. So why don't you specify the website you are referring to? Mr. Mock asked about the issue of recording. There are already audio recordings as well as lyrics and scores of the national anthem, but with the national anthem law, the central government is compiling another official audio recording. So it is about which version of the official recording would be referred to. After the bill is passed, when the recording and standard score are published, we would make announcements through the ISD. So if the names of the bureaus and departments are specified, and if there are changes to the structures or names of these departments or bureaus, then we would need to amend the legislation. Well, the current confusion is that it might refer to any website of the government. By provided for the purposes of this section on the website, it means that the recording is uploaded for the sake of enforcing this recording. So even if other government departments uploads a recording, but it is not for the purpose of this section, it would not apply. I want to follow up on what Mr. Al-Lokin said. So for events organized by the government in Annex or Schedule 3, so for area committees district councils, etc., would their events be considered events organized by the government? So how do we find out how these occasions are defined? The SAR government obviously includes the policy bureaus and departments of the government, and district councils are not administrative units or policy bureaus of the government. In other words, for certain funds, for example, the civil or civic education fund, would they be included? Well, this is a hypothetical scenario. Well, it would not be considered a major sporting event held by the government. For the National Day reception, different organizations might apply for funding. So if for such events not held by the government, the organizer can choose whether or not to play the national anthem. Correct. Mr. Ray Chan, 3 minutes. I want to ask about clause 5 brackets 3. The provision is rather long, and I find it rather unclear. It says, in this section, a reference to the national anthem being played and sung is a reference to the national anthem being played on musical instruments in accordance with the standard score, or an official recording of the national anthem being played for the singing of the national anthem. So, is singing of the national anthem a requirement imposed on participants, or is it the case that the organizer has to provide or sing or play the national anthem so that participants can fulfill the requirement of singing the anthem? If this is not the case, well, the title of this clause should read, the anthem must be played and sung. The understanding is correct. The organizer must play the official recording in accordance with the standard score so that participants can sing the anthem. And this is imposed on the organizer. So in that case, can you simply say the anthem must be played and the anthem does not have to be sung? In terms of the title of the clause, Mr. Pang. Thank you. We have described the playing and singing of the national anthem in this bill to correspond to the concept of playing and singing the anthem in the national anthem law. So we explained what the playing and singing of the national anthem means. I think when you say the national anthem must be played and sung, it is not clear enough. For example, if you say the tidy uniform must be worn, it means that in the entire occasion, the requirement must be met. But for the playing of the national anthem, so long as it happens once, you are seen as fulfilling the provision. So does it mean that when the flag is raised, should you say playing and singing the anthem before or during the occasion? The legal requirement is playing and singing the national anthem, but as to when the anthem is actually played or sung, it depends on the occasion itself. But from my understanding, it usually takes place at the beginning of the occasion.
I want to ask about major sporting events. You're talking about one event or multiple events? You say that the Hong Kong Games is one such event. You're talking about all matches under the Hong Kong Games where national anthems must be played and the flag goes up, or are you only talking about the opening ceremony of Hong Kong Games? I think it is up to the organizing body within the Hong Kong SAR government to decide which is which. So it's up to him totally, as long as he so decides and it is legal. If that is the case, I would like to ask the legal advisor here. I have also looked at the English version.
Held by the government。咁我想問呢個 held 或者舉辦喺
So I'd like to know whether held means host, legally speaking. So your question is directed at the legal advisor, our legal advisor, yes. There is no set legal definition for it, and so you can only go by the dictionary definition. And holding and hosting actually are very similar in meaning. So it means being the lead organizing body of an event. So there is the meaning that this event is being organized in the main by a certain body. If that is the case, then I think you should use the word host instead of simply holding. I think that's more clear. Of course, there are many different ways to express a concept. Hold, held, host, organize actually all point to the same meaning that a certain body is organizing an event as a lead organizer. Mr. Chu Hoi-dik, my question has to do with 5-1. Colleagues have mentioned, like Mr. Au Nok Kin has mentioned, that Part 2 is superfluous. Because if Clause 5 outlines occasions on which national anthem must be played, and these occasions are defined as government-hosted events, then of course the government will automatically play the national anthem. Now, other events that might not come under this category would be events like the inauguration of a Legislative Council session or the swearing in of Legislative Council members. Now, my position is that actually clauses 3, 4, and 5 can be done away with because we're talking about separation of three powers: legislature, executive, and judiciary. But back to clause 5. Now, when we adapt the national law into clause 5, is there any political overtone suggesting that the central government actually is not totally confident in the Hong Kong SAR government? Because if you look at clause 4 of national law and national anthem, mention is being made of 9 occasions where national anthem must be played, and the word being used is should or ought to. And if you look at interpretation clause of the bill, the word should is also being used. But now, coming to 5-1, another word is being used, and it does not follow the national law's wording of using the expression should, but using the expression must be instead. My first impression of this is that must be is stricter than should. So the entire thing gives me the impression that the central government actually does not have confidence in Hong Kong's government or legislature. Now, because the central government is not totally confident, that's why the central government directs you to use the word must be. Is that the case? Can you confirm or deny that? Now, can you let us know what's the rationale of using must be instead of should? Before I hand the floor over to the law draftsman, I just want to clarify that even in the national law or national anthem, an exhaustive list of all occasions where national anthem must be played actually is being provided. Indeed, we have taken reference from mainland documents. Should and must be actually are both expressions that can be used to suggest that a legal responsibility has to be shouldered. The difference is that in mainland legislation, if the word should is being used, then no penalties or legal consequences or criminal consequences would result. However, in Hong Kong, we do not, in law drafting, use the word should, and that's why we use must be instead. Now, for bracket 5, for clause 5, bracket 3. Now it says, national anthem being played on musical instruments in accordance with the standard score. I just want to know whether there is any attempt to define musical instruments. I think the keyword here is in this section, which is the opening of 5 bracket 3. So, which means that the requirement only applies to clause 5. The State Department is going to provide an official recording, especially for our bill, and also there will be a standard score for our bill. And there are 3 versions of the bill. One is for symphonic performance, another is for orchestral performance, and the third one is for piano performance, so that different occasions can use the suitable version. So concerning the standard score as set in clause 5,
叫做撰寫嘅方式咯。
concerning the write-up of the score, it is written in such a way that certain musical instruments will be specified for the playing of national anthem. Now, your understanding is correct, because there is already an official recording for national anthem as well as a standard score for national anthem for the mainland. Now, after national anthem legislation is passed on the mainland, they are now redoing the official recording and the standard score. And when Hong Kong's NA legislation comes into effect, the same will be done for Hong Kong. And so the orchestral version as well as the symphonic version will all have directions as to what musical instruments can be used. So there is no question that traditional Chinese musical instruments will not be featured in the playing of national anthem. Indeed, they will not be featured in the standard score or the official recording, but I'm not talking about breaking the law or violating the law here, because the hosting organizations will not provide such a version anyway. Mr. Chu, I'm not sure whether my question has already been asked. If so, you can remind me. I want to talk about 5 bracket 2. The CE in Council made by notice published in the Gazette amend Schedule 3. As I mentioned earlier on, now Schedule 3 occasions are all government hosted organizations, so you are merely governing yourselves. But for bracket 2, on the face of it, it seems that there is no catchment parameters here. So to what extent can Schedule 3 be amended? There is no indication here. Let me give you an example. A very straightforward one. Can Schedule 3 be amended so that not only government events are caught, but also private events can be caught, or events that are subvented by the governments can also be caught, such as events being held at schools, subvented schools, and also under the national law. NPC organizations and organizations under NPC can also be caught. So can Schedule 3 be amended so that each time Legislative Council has a full council meeting, national anthem must be played? Can Schedule 3 be amended to such an effect? So what is the parameters of amending Schedule 3? Now Schedule 3 can be amended in accordance with 5(2). And the method of amendment is to present the bill first and the legislation first and scrutinize later. And so Schedule 3 can be amended only with approval from LegCo. So you're talking about private events and subvented events and LegCo events. They can, or they could all be included under Schedule 3 by an amendment approved under the positive vetting procedure, right? Now, Schedule 3 at present is to cover major sporting events. Logically speaking, what you said could happen. Now, if logically that is possible, then my question for the government is, why do you want to allow such a logical possibility to exist? Because if what you have in mind is only to catch government-hosted events as a major catchment for the legislation, then why do you want to allow such a logical loophole to exist? Because you want to assure members public. We are, first of all, talking about government events. And in the final analysis, LegCo is going to be the gatekeeper here. The LegCo is going to safeguard people's rights because you have final approving right over amendment to Schedule 3. Mr. Ray Chan, just now it was said that 3 types of standard scores will be provided: orchestral version, symphonic version, and the third one. Now, what's the difference between the first two? I'd like to know whether all 3 standard scores, orchestral, symphonic, and piano, will all be made available before the third reading of the bill. Because I have looked at Schedule 3 occasions, such as each month, the first day of each month, flag hoisting ceremony, and also July 1st, National Day. Now, the national anthem on those occasions will be played by the marching band of the police force live. And on other occasions, under Schedule 3, official recordings will be played. So now that you say that 3 scores will be provided: symphonic, orchestral, and piano. And so these, of course, will meet the requirements, presumably. Now, say at the LegCo oath-taking ceremony, say if we were to get a traditional Chinese orchestra to come in to play national anthem with Chinese musical instruments, will we be violating the law? So I want to know whether all 3 scores will be made available before third reading of the bill. Because once third reading happens, then the bill will come into effect. As I said earlier on, the State Department is preparing the 3 scores. Can you say once again what 3 versions are they? Orchestral, symphonic, as well as piano versions. And you will see these 3 scores before you pass the bill into legislation. And the use of Chinese musical instruments will not meet the requirement. And so percussion or percussive and musical instruments will also not be allowed. No. Mr. Au Lok Hin. I see that There is no quorum here, and so let's take a count, head count. Okay, let's ring the bell.
好，跟住落繼續會議啊。
Next, Ms. Claudia Mo, third round, 2 minutes. For those who wish to speak, please press the button because I'm going to draw the line in 5 minutes. Ms. Claudia Mo. I was just looking through the online Oxford Dictionary. Did Mr. Pang mislead me because he seemed quite right just now? Yet for clause 5 bracket 4 for official recording and standard score, it says a recording of national anthem provided for the purposes of this section. Why is it in plural form? Mr. Pang just now said that it is how you use the recording. But then when I look through the Oxford Dictionary, it said that purpose definition is a sort of like an objective. So if you want to put it in plural form, it can be used as tax purposes, because for tax purposes there will be more than one. But then here, the meaning here is for the purpose of this section. Why do you need to put this in plural form? Well, you said that this points to what do you mean by that, Mr. Pang? Well, we put purposes of this section because we're talking about the implementation of the section. So that is how we interpret it. So if you're looking into the implementation of the purpose, then the Chinese would be 施行條例. We decided to put in plural form because it is for the implementation. So in Hong Kong, when we put for the purposes of this section, then the meaning is the implementation of this section. So why don't you put the implementation? Why can you use this directly? Well, this is the habitual use in our legislation. Mr. Chu Hoi Dik, I'd like to follow up on my question on should becoming a must be a national law. Mr. Pang's explanation, I'm not quite sure I understand correctly. Do you mean to say that should be and must be can be interchangeable? So we could either choose to use should or choose to use must be. Well, perhaps I wasn't clear. Should and must be are both legal responsibilities, but for should, I see that there is no criminal liability. Yet for must be, then there is a liability. In Hong Kong, however, should and must be can be interchangeable. We can choose to use the word must be in place of should. Well, if you say that there is no criminal liability using should, and since clause 5 is just a guideline, then why do you choose the word should and not must be? Well, for the national flag law in clause 4, they also choose to use the term must be, so we want it to be consistent. Well, Chairman, I think that must be should be a level up. It seems should be more appropriate than must be if you say that there is no criminal liability. Mr. Ao Nok Him, Chairman, I would like to follow up on the letter given by the Hong Kong Bar Association in April. I'm not sure whether you have read it. It said that the part 2, the whole of part 2, including on etiquette for playing and singing, is not necessary. 亦都係唔會咧，就係削弱咗我哋呢個國家法嘅。So it would not affect the original intention. So have you read the letter? Yes, we did read the letter. But then when we are drawing up legislation, we must look into the spirit of the national law, and we believe that it is more appropriate to keep part 2. Rules of procedure. Well, I only have 1 more minute. I'd like to follow up. What does he want to say? Well, you said you're going to give her 5 minutes. I'm not able to press the button. I said that I will draw the line in 5 minutes. So how do you count the 5 minutes? Your watch or my watch? Well, from when I first started talking, well, you have to respect each other and say that, well, 5 minutes. Well, how about I do this? Well, for those who still want to speak, you may press the button now. I am going to draw the line now. If you wish to speak, please press the button. Because last time, Miss Claudia Mo complained to me that since that last time she thought that she could still continue to press the speak button. Well, you yelled at me. Did you remember? All right. I am going to draw the line now. Next. I'll read it out. Mr. Ray Chan, Dr. Chen Chung Tan, Ms. Claudia Mo, Mr. Gary Fan, Mr. Ao Nok Kim, Dr. Fernando Chung, Mr. Chu Hortic, Mr. Chen Chi Jun. 4th round, 1 minute. Well, I understand you need to control the meeting, but I don't know why you are so in a rush that you're holding meetings Saturday and Monday. I'm not going to repeat clause 5, but in clause 5 it does not say who will be responsible for playing or singing the national anthem. Well, let's say the flag ceremony, there would be the person hanging up the flag will be responsible for that. But here it does not say or state who is responsible for the playing and singing of the national anthem. Well, since you require legislative councillors to also sing the national anthem when taking oath, well, you need to invite a band to come over. Who will be responsible for the playing of the national anthem? Chairman, in clause 5, this is talking about occasions on which national anthem must be played and sung, so it does not refer to individual occasions. If you look at Schedule 3, there are different organizers for the different occasions, and so the organizer, of course, would be responsible for the playing of the national anthem. Dr. Fernando Chang, 3 minutes. Yes, Schedule 3 mentions the different occasions on which the national anthem must be played, and one is the national flag raising ceremony. That includes 3 occasions. Should the national anthem be played when the flag is being raised, or can the national anthem be played at different times? Because Schedule 3 does not state clearly that the national anthem be played simultaneously with the flag raising. Are we allowing a flexibility here, or did we leave it out? P.S. Flag raising ceremony. All the ceremonies are held by the government, and we do have our procedures. These procedures would list out what should be done at what times. It doesn't specify the minute and seconds. No, my question is whether the national anthem should be played when the flag is being risen. But we didn't specify it here in Schedule 3. It just mentioned the flag raising ceremony. It doesn't specify that the national anthem be played and sung during the raising of the flag. I just want to ask whether you draft it like this. Intentionally to allow some flexibility that flag raising could be done when the anthem is not played. Chairman, there is no such requirement in the national law. Well, yes, that's why I'm asking you now. Well, there are many things under the national law that differs from our bill. So that is the reason why I'm asking you. The 3 flag raising ceremonies listed in Schedule 3 are important official ceremonies. If you do not specify, then the flag could be raised after the anthem has been played or before the anthem is played. Can you specify clearly? Chairman, we will consider Dr. Chung's views. Mr. Pt2, Chairman, well, I just heard that you drew the line. Well, I just went out to use the washroom, and I came back finding that the line has been drawn. Well, can you be more tolerant? Because I just went to the restroom. Can you allow me to ask a second round? Well, I don't know how long you went to use the washroom. Well, I just don't want to argue with you. I want you to be tolerant to allow me to ask one more round. You have to explain to the public why you need to draw the line. A clause-by-clause scrutiny is very important. We need to understand the intention behind each clause. We have prepared many questions. We're not repeating the questions. Because at that time only one member indicated his wish to speak. I did tell them that I'm going to draw the line in 5 minutes, and then I say that in 5 minutes I am going to draw the line, and then I reminded once again after the 5 minutes. Well, yes, I understand, but you shouldn't draw the line. I've just asked one round. Well, if we are at the 10th round, then I understand, but I only asked one round. Oh yes, I'm not going to argue with you. I don't want to be unfair to other members. You can't draw the line like this. You're abusing your power, Chairman. Mr. Gary Fan, Chairman. Rules of procedure. Well, just now you said that no one pressed the button to speak. Well, some members choose not to speak and not to ask questions. That's their choice. But then we have questions. You should allow us to speak. Mr. Chan Ji-chun told you that he has 10 questions. He's only allowed to ask 3 or 4 rounds. I'm helping him to ask the 5th and 6th question. Chairman, this is not a fair way in holding the meeting. Well, I'm not able to keep track of where you are. I say that I'm going to draw the line after 5 minutes after the quorum bell has rung. You need to give us a reasonable answer why you need to draw a line and not give us more time to ask questions. I think I have to be. I'm asking Mr. Ray Chen to ask the questions that he has prepared. This is not an ideal way of convening the meeting. I understand your concern. Mr. Chu Hoi-Dick. I would like to clarify a situation. Very often, when you talk about drawing the line, and then you give us a time, sometimes a time period. Well, we are mostly present. Well, yes, sometimes. Well, you set a time limit and say that you're going to draw the line after that. So that means that you only allow one more round of questions. However, we want to communicate to you that, well, since we are all present at the meeting and we have 5 or 6 questions we would like to ask, yet by drawing the line, you are limiting our chances to ask questions, because even if I start sitting here at 2:30, I will still not be allowed to ask all my questions. Well, if you say that, well, since you're not here, then I'm sure you have no more questions. Well, I don't want you to cut this across the board. If you think that we are all sitting here, we are all present, and that we all have questions to ask, and we do not leave the room, would you consider that you would allow us more flexibility and not just to draw the line across the board?
一下就即係話
Mr. Chu, for the first time, I would remind members to press the button if they wish to speak, and after some time, I would announce that I will draw the line 5 or 10 minutes later. Well, I'm not trying to argue with you over this. Well, please let me finish. I've heard you. So, in the future, in between the my first announcement and the final reminder, I would issue another reminder, but I must preside over the meeting effectively. I cannot reserve a lot of time to see if you are coming back. In that case, I would not be able to chair this meeting. It's not about whether I come back. If we are going to have 5 rounds each, under your current approach, I would not be able to ask my questions. All right, your comment is noted. So from now, I would see whether the questions asked are redundant or whether the questions are no longer meaningful. It is hard to draw an arbitrary line. Clause 7 is very complicated. If you still adopt the 4-3-2-1 minute approach, then our discussion cannot continue. That's our long-standing practice. Well, this 4-3-2-1 approach is not right. This has been the convention at the Bills Committee. Well, I know very well because myself and Mr. Martin Liao chaired the meetings. Chairman, since the setting up of the Bills Committee, well, the practice has been wrong from day one. You and Mr. Martin Liao should not draw the line in this manner. Well, I'm giving you the chance to explain yourself to the public. Where is the urgency? What is your objective? When do you intend to complete the work? Well, Chairman, I'm not done yet. Please do not speak on top of each other. So I suggest that you chair the meeting in an orderly manner. Well, even if you allow each member to speak 10 times, then it would only take 15 or 16 minutes. That would be a fairer approach. So for members who have other matters to attend to, by the time they come back, they cannot speak anymore. If I only have 4 minutes for my question, is it fair? Can I ask anything meaningful? This is unfair. Are you done, Mr. Hui? Can you tell us what your deadline in mind is? Please explain your deadline, Chairman. Well, why the urgency? Please speak in turn. Dr. Chang. Please switch on the microphone. Chairman, at any committee meeting, the chairman can decide the time limit for different items, whether it is a panel meeting or a bills committee meeting. There were plenty of precedents. Chairman, you have the power to draw the line based on a certain system. So for members who wish to ask further questions, well, for example, if a member raises a question, the government can offer a written response later, depending on the time. If time allows, you can allow questions from a few more members. I think this can be done. So how much time is needed for this item? I think the chairman is empowered to make a decision. Ms. Holden Chow. Thank you, Chairman. For the amount of time assigned, as chairman, you have the right to make a decision. Since you have decided to draw a line in order to effectively manage a meeting, I would agree with that approach. Some pan-democrats would like to change this approach, for example, by allowing a certain number of rounds for each member. In the past, in committee or panel meetings, there was such practice of drawing a line. So I think you should be drawing a line in order to effectively administer a meeting. Mr. Gary Fan, we must be consistent. In the committee meeting chaired by Mr. James Ho last week, he was constantly questioned over his approach of managing the meeting. Well, we should not normalize your approach of drawing the line. Mr. Ray Chan indicated very early that he had 10 questions to ask, and now we are wasting time in this discussion. If you are going to draw a line, you have to indicate that ahead of a meeting. So you should notify us. And now we are here. We have prepared all our questions. We are at the clause-by-clause examination. We should be allowed to ask our questions. We are just discharging our duties. For things that are not clear, we must seek to clarify them. I have been here throughout the entire meeting. It's just that I've been coming in and out. Are you done? I don't agree with your approach of drawing a line. I hope you acknowledge that. Are you done? I do not know. Are you done? Well, I would use my intonations. It doesn't mean you would stumble. Well, using the pause is a technique. That's why I'm asking you that question, Mr. Fan. If not, Mr. Vincent Chang, Ms. Claudia Mo, Dr. Fernando Chang, Ms. Ao Loh-Hin, Mr. Ted Hui. 1 minute each. Chairman, I don't agree with Mr. Gary Fan. We must have progress in our meetings. We cannot have unlimited number of turns. I've been here since 2:30, and we have been on clause 5 for a very long time. I feel that there were redundancies, but as members, we should be open. But at the same time, we must ensure efficiency, and there should be and a line should be drawn. So I hope under your leadership, you can ensure the flow of the meeting. Ms. Claudia Mo, in terms of drawing a line, well, you you appear to be courteous and polite. Well, I only asked some 2 or 3 rounds. Well, please remind me. I cannot remember exactly the number of times. Yes, I spoke 3 times, but under your approach, I should be entitled to at least some multiple rounds of 4, 3, 2, and 1 minute each. So I am entitled to another round. I do not see why you decided to impose limits, and like other members suggested, we can ask for a written response from the government. But as we all know, to prepare a written response, it takes a lot of effort and time. You need to ask people to type and check and proofread, and this is really a waste of time. So Dr. Chang's idea had a good intention, but if this happens, then the civil servants would be very busy. Some of the questions only need a straightforward answer. Dr. Fernando Chang, I've been here for more than 10 years. I took part in a lot of Bills Committee and panel meetings. At panel meetings, we have specific agendas, and there's a time limit for each agenda or item. So when members speak, well, drawing the line is generally an acceptable practice. At Bills Committees, the laws we are scrutinizing have deep consequences. So whether for the initial scrutiny or clause-by-clause examination, no line would usually be drawn unless there is an urgent need. For example, the bill must be passed within a deadline, or there would be irreversible consequences. Then those cases would warrant a limit to speaking time. If the chairman feels that members were repeating themselves or that their questions are irrelevant to the theme, or if their speeches are frivolous and meaningless, you can stop them anytime or restrict their right to speak. So that is the convention at LegCo as I see it. So I hope we would respect our convention, because the legislation has far-reaching consequences. If you feel there's urgency, you should explain to us why a line should be drawn. Ms. Al-Lohin, Chairman, I wonder whether you watch the drama at night. This is you should not draw a line casually. This is not like a move in the martial arts drama. The Bar Association said some provisions under Part 2 are not in line with the Convention of the Common Law. I don't know what members make of the view of the Bar. But we should consider why the barristers issued such a strong statement in the name of the Bar Association. We are now scrutinizing Part 2 of the bill. If you continue to contravene the Convention of the Common Law jurisdiction, is it reasonable? We are yet to touch these issues. Next, Mr. Wu Chi-wai. Chairman, as chairman, of course, you can judge whether the speeches of members are frivolous or meaningless. But for questions already asked by members, after a response was given by the Secretariat, we did not seek to filibuster in the subsequent speeches. Well, we are at a Bills Committee. I think drawing lines at a Bills Committee meeting would have far-reaching consequences. Mr. Martin Liao adopted the same approach, and I find this highly undesirable. I think your job is to decide whether our speeches are frivolous and meaningless instead of drawing a line. Well, I would give you time to answer this question. What is the time frame you have in mind, and is there any urgency in scrutinizing the bill? I'm inviting you to answer this question. Well, I would offer an overall response later. And the second question is for the Secretariat. Is drawing a line the convention of LegCo. In past Bills Committee meetings, we used to have unlimited turns in the policy discussion and clause-by-clause examination. I invite the clerk to respond. Will you invite the clerk to respond? Are you going to ask the clerk to respond? Legal advisor. The conventions in the past were different. There were no time limits in the past. Mr. Chen Kim-po. Of course, members would want maximum time for questions, so usually they would request more time for questions. But the job of a chairman is to maintain the order and efficiency of the meeting, so the outcome might not be popular with every member. The chairman must draw a line in order to ensure progress, and members would realize that they can ask written questions of the government. And after the chairman makes a decision, the decision cannot be challenged by members. Mr. Ray Chen, are you the final member to speak? From my experience, at most Bills Committee meetings, at the clause-by-clause examination in particular, we would move on to from one clause to the next when there are no more questions naturally from members. And well, in terms of ensuring order of the meeting, you have to tell us that you are going to intervene because there's a lack of efficiency. It's not about whether you are empowered to do so. You have to explain the matter to members and the public. There will be another meeting on Saturday and then next Monday. So you have to see whether we find the approach reasonable. So we should have a discussion over this. Dr. Lena Wong. Well, I will be very quick. I have questions on Clause 5. I was at a public hearing, and I have 2 questions about Clause 5, so I hope I'm allowed to ask those questions. Any other point of order? I would offer an overall response. So for members who were here, you would know that if I feel that a question is worth answering, even though the time limit has lapsed, I would allow the government to respond. I have been lenient in my timekeeping because I wanted the government to address meaningful questions from members. I've heard members' views. And in terms of drawing a line, I feel that I have to administer the meeting effectively. Mr. Tet-Hui asked whether there's any urgency. Well, at the Bills Committee meetings, there's no stipulation on when it should be completed, but according to the handbook, normally Bills Committee scrutiny should be completed within 3 months. So this is a guideline. So under this guideline, I hope to effectively administer the scrutiny of the provisions. But of course, I should be careful in identifying whether the questions asked are redundant or correlate to the theme or provisions. So in subsequent scrutiny, I would adhere to these principles. Mr. Ted asked whether each member should be given 10 turns. As chairman, it is hard for me to draw a line in that manner. I cannot give 10 rounds to each members because that would be an arbitrary number. Because some members might feel that each should be given 15 rounds. So from now, I would adhere to these principles. Dr. Wong, I would address your question in a moment. So for members waiting to speak on Clause 5.
After I announce that a line will be drawn, there are 5 members outstanding waiting to speak. Of course, regarding Clause 5, I have already heard your comments, and I just want to say that there is no rush for me to complete scrutiny on this item or on this clause today. If you do not object, then I would allow Madam Helena Wong to speak. Do you object to that? What about me? Mr. Hui and Madam Wong will be allowed to speak after the 5 members, outstanding members. I asked the Secretariat to give me an answer, and you promised that they would do so. I just want to know, before today or before this Bills Committee, all Bills Committee's scrutiny will not be subject to any time limit. Why is it that all of a sudden there is a time limit now? Now, I just want to make sure that the drawing of the line here is in accordance with rules of procedures. I want to ask about the history. I want to ask about the historical background. I want to ask about the convention of the council. So why can't you let the Secretariat answer me? Secretariat, why don't you answer him? Why don't you answer him in a very simple way? Now, is it that the pro-establishment political parties will be given the final say over this? Now, Secretariat, I don't know whether the Secretariat can give you an immediate answer. Now, because Mr. Hui asked this question here and now, there wasn't any time for me to dig up the information. Now, what about from memory? From my observation, regarding using the drawing of line for timekeeping, actually that has happened before. But what about allowing members to exhaust all their questions before going on to the next item? Indeed, that has also happened. Mr. Zhang? Chairman, would you clarify this? Just now you said that you're going to give regard as to whether questions from members have become repetitive or relevant, and you are going to exercise your judgment as to whether or not to draw a line over that. Does it mean that you are not going to draw a line anymore? Because if you continue to draw the line, then it would be pointless. Mr. Chang, I have already made it very clear. If at a certain point I am of the view that members' questions have become repetitive or have become irrelevant to the provisions of the bill, or questions have more or less been exhausted, then I would announce that after a certain period of time, say within 7 or 10 minutes, I would draw the line, because I have to draw a line somewhere. It cannot go on forever. And in the past, other bills committees have also adopted the same approach. And you can see that I have jotted down all questions asked by members because I want to be scientific here when it comes to drawing of line. When it comes to my judging as to whether questions have become repetitive. I'm not saying that, say, after 2 hours, then I have to draw the line. It's not arbitrary like that. I hope that before you draw the line, you're going to consult us. I think that would be the fairer way of approaching the subject. But you have to understand that all of us here have different opinions. I am going to look at your record of asking questions before making a judgment, and also my own personal interpretation. I hope that if certain individual members have got several important questions or only a few questions left, then I think you should give them some leeway. Madam Claudia Mo, do you have any questions about procedures? I just want to clarify what you just said. On one hand, you say that when questions have been more or less exhausted, I take it that that's a way of expression. And on the other hand, you say that you want to be scientific about it. More or less exhaustive really is not equal to having exhausted all the questions. And the handbook on the rules of procedures say that all members should have equal opportunities and ample opportunities to raise questions. I hope that you can also give regard to this. Otherwise, argument will go on forever. Ample opportunities does not mean that questions can be allowed to be repetitive and also frivolous. Mr. Hui, last time to speak, please. Now, I don't want to give public or you the impression that I'm trying to stall things. I hope that I can put on record that I do not accept your approach of drawing the line. I just want to put on record that I do not agree with your way of drawing the line at a point of your judgment. And secondly, to follow up on Secretariat's point, indeed, some Bills Committee in the past have allowed members to exhaust all the questions, but other Bills Committees have adopted drawing the line approach. I just want to know why did you decide to adopt the drawing the line approach? I decided to adopt the drawing the line approach because the handbook says that there is a guideline that says that we should complete scrutiny of a particular bill within 3 months. And also I want to keep the meeting efficient. I want to keep our proceedings efficient. Of course, other Bills Committees may have different approaches, but me and Mr. Liu have decided that this is the right approach. Now, I think this approach has been wrong all along. Mr. Fan, third time. I want to ask about Part 2, Clause 5, Bracket 3. I have paid attention to both the English and the Chinese version and the chorus bonding relation between them. If there is in discrepancy, I think you should iron it out. Now, in Chinese, it only says musical instrument, which doesn't say whether it's plural or singular. But in English, it's musical instruments, which is plural. Now, for Schedule 3 occasions, if national anthem is to be played, does it mean that there must be more than one musical instrument playing the national anthem, say in the form of a symphony, rather than just using one musical instrument?
秘書長，
主席好多謝范議員。
I want to thank Mr. Fan for his question. Indeed, in the English version, there is the plural form of musical instruments, but in Chinese, it is very rare for us to present a particular object in a plural form. And in Part 1 interpretation, or in Cap 1 interpretation ordinance, actually, a singular form in Chinese can also denote more than one item or more than one object, or the plural form. And second question is the official recording. The permanent sec just now said that the official recording is to be readied in due course. I just want to know whether the official recording has a vocal part. The reason why I ask that question is whether a vocalized official recording is really the most appropriate action. appropriate version. Because if there is a vocal part to the official recording, then it might overshadow the live singing of the audience or the spectators. Now, is there any chance that the vocal section or vocal part of the official recording will overshadow or overwhelm the singing of the national anthem by live audience? Now, there is a instrumental version for the official recording and also a vocalized version for the official recording, and it's up to the organizer to choose which to play. Mr. Zhang, just now you said that both the official recording and standard score will be uploaded to the government website. However, earlier on the government said that they're still awaiting the official recording and standard score versions to be finalized by the State Department. I've looked at mainland Chinese website, whether it's the annotated version or the full score version or the orchestral score or the piano score or the symphonic score or the vocalized version. The mainland Chinese authority website says that the versions are provided by two organizations. One is CCTV, the other is People's Publication Company. So I just want to ask the government, concerning the finalized versions, are they simply handed to you by State Department, or are they versions prepared by the two organizations listed in mainland Chinese authorities' website? Because I'm not only worried about copyright, I'm worried about in what capacity do you accept a production from the People's Publication Company and to treat it as the official version. Now, the version that will be given to us will be from the State Department, and that will be the version that will be used countrywide across PRC. Madam Claudia Mo. Now, concerning official recording and standard score, I'd like to, originally I wanted to ask what's the sources. You already answered that both of them will be from the State Department. Yes, they will be from the State Department. So a certain big orchestra will play it and record it in Beijing, and then the version will be given to you. So that is really something that is very intriguing to me. Mr. Zhang has already asked my question. So that brings me to this question. Obviously, our national anthem has shown a lot of influence from the French Revolution or from Russia. And so there is no question of it being played by traditional Chinese musical instruments like erhu. You mentioned that there are going to be 3 versions of the score, symphonic, orchestral, as well as piano. I just want to know why is it that there is no violin recital version or violin solo version for the national anthem, because that is a feature of many other countries' national anthems. Now, because the State Department is going to provide 3 versions, and so for official occasions or government occasions, we are going to only use one of these 3 versions. As for occasions outside of the Schedule 3 occasions, then members of the public actually have a lot of freedom in choosing whatever versions they use. Members of the public can simply download the versions from government websites. Yes, they're welcome to do so. Mr. Zhang? Or Mr. Zhu, sorry. I recall that it's been mentioned that oath-taking ceremony and the playing of national anthem will go hand in hand together, and playing of anthem will become part of oath-taking ceremony. Now, according to NPC's interpretation of Article 104 of Basic Law, there is a special part in the interpretation that says that the oath taking ceremony will feature an oath that is being taken to show that the one taking the oath is making a legal pledge to the People's Republic of Chinese government as well as the Hong Kong SAR government. And so is it that you try to include oath-taking as an occasion for playing of national anthem in order to tie in with that interpretation of Article 104? Now, there is no such correlation. The national law says that one of the occasions where national anthem has to be played is the oath-taking ceremony in accordance with the national constitution. And so we believe that in accordance with Article 104, it is only right that Legislative Council's oath-taking ceremony should be included as one of the occasions where national anthem has to be played. Mr. Ao Dok Him, the Bar Society has provided a letter dated April 2nd, and it says that Part 2 should be taken out of the bill and it will have no adverse impact. Now, are you going to give a written reply to the Bar Association? This is question number 1. Secondly, concerning Schedule 3, Schedule 3 says that there are certain occasions where national anthem must be played and also when national flag goes up. So are you saying that all occasions where national flag goes up will feature or must feature the playing of national anthem? Or alternatively, is it that there is no mandatory relationship between the two? So does it mean that if a flag goes up in the school, then it would be one of the occasions where national anthem must be played? Now, I answer part 1 of your question. Indeed, we have taken note of the Bar Association's letter, and also we have been communicating with other law industries organizations. But we have already made it clear that Part 2 is necessary because we really want to realize and manifest the spirit and the legislative intent of national law and national anthem. As for Part 2 of the question concerning the raising of flag occasions that it says here include, and so it is indeed include all events or the ceremony where the flag has to be hoisted. So it means that if flag is hoisted, and if they want to play national anthem, then they have to comply with Clause 5. Madam Helena Wong. So Clause 5 is about what occasions must feature the playing of national anthem. Now, what if there is an occasion where national anthem must be played and yet has not been played? Is there going to be any penalty? If so, what is going to be the penalty? Actually, Part 2, Clause 5 does not carry any penalties. And so if the national anthem is not being played or sung on an occasion where it must be played and sung, no one will be punished and there will be no penalties. Indeed, in accordance with the national law, so even if someone deliberately or unintentionally fails to play and sing national anthem at an occasion where it must be played, then there will be no penalty? No. Okay, we can continue to ask about Schedule 3, right? Yes? Now, Schedule 3, 1E, Legislative Council swearing in ceremony. So that is the swearing in ceremony for newly elected members. So national anthem should be played before each member being sworn in, or before all members being sworn in only once, I mean. So before any members is being sworn in, then there is only the playing of national anthem once. Okay, so it's played once and then members can all sworn in one by one. Say if you are not number 1 in the line, and I'm actually last in the line, and I because I'm very late in the line, and so I am not yet present within the chamber or in my seat, and so I miss the stretch where national anthem is being played because the rules and procedures do not require us to be in our seat all the time. And so if I am not in my seat or not in the chamber where national anthem is being played, then would I be penalized? Now, for national anthem law, there is no such requirement as set by Madam Helena Wong. However, when legislative councils are being sworn in, and when the playing of national anthem is part of the oath-taking ceremony, then you have to give regard to Article 104 and also existing Hong Kong legislation in the form of oath and declaration ordinance. When a presiding officer is to decide whether or not a particular member has completed the oath, then he will have to give regard to all of these factors. And the court ruling has already indicated that it has authority over overturning a presiding officer's ruling. Now, are there any other pieces of legislation that have to be amended accordingly or correspondingly in order to clarify that when newly elected members are being sworn in, they must be present at a time when national anthem is being played? Otherwise, they risk being considered not having completed the oath.
Well, as we are only talking about the ceremony here, well, there are standards on what sort of behavior that should be at the playing and singing of national anthem. Well, because when the law is written, there was no ceremony on oath taking and singing of national anthem. So there is a gray area here. So if members did not attend the national anthem singing part of the ceremony, would that member be in breach of articles inclusive of Article 104 and other articles, which will make invalid the oath? This is not very clear because when we drew up this legislation, the national anthem bill was not yet formulated. Chairman. Well, the oath and declaration ordinance already exists in Hong Kong legislation, and the national anthem bill will not override Article 104. Right now, the presiding officer has the authority, and the national anthem bill will not change the authority of the presiding officer. Well, but it doesn't state clearly whether a member who is not present at the national anthem singing will be seen as not completing the oath taking ceremony. So the presiding officer now will have to interpret it himself, and members may be disqualified because of that. This is very serious. So why do you think that there does not need to have a clear interpretation for that? Chairman, Article 104 and Oaths and Declarations Ordinance have been interpreted in many court cases recently, and there have been very clear guidelines on how to interpret these ordinances. Mr. Pt2. Thank you. Schedule 3 lists out 15 occasions on which national anthem must be played and sung. My understanding is that these occasions are all listed under Clause 4, in which 9 occasions are listed under the national law. I see in the Hong Kong version that there are at least 2 that is in relation to legal ceremony. One is the judicial oath, and the other is the Legislative Council oath. At the ceremonial opening of the legal year. So which law does it correlate with the national law for the ceremonial opening of the legal year? Well, right now there is already the singing of the national anthem at the ceremonial opening of the legal year. Well, it does not have to fall into any of the 9 occasions. What is the reasons behind that? Well, so that is on other occasions in which national anthem must be played. So that is exactly what I want to ask about. Other occasions can be very broad. The chief executive can amend the schedule. What do you mean by other occasions? It can be any occasion. It can be any occasion in Hong Kong. I'm sure that with LegCo being the gatekeeper, this hypothesis should not happen. Well, I remember that you have consulted the legal system and that they support the playing and singing of the national anthem at the ceremonial opening of the legal year. Yes, they are in support of this. Well, taking judicial oath and ceremonial opening of the legal year, and both being occasions in which national anthem are being supported by the legal sector. Yes. All right, we have completed with the clause by clause scrutiny for clause 5. We're now going to move on to clause 6. Before I invite the government to go through this, I suggest that we look at clause 6 and clause 8 together because they are closely linked to each other. 6 is offense of misuse of national anthem. National anthem, lyrics and score of the national anthem. Its definition are explained in clause 8. So I suggest that we go through these 2 clauses together. Mr. Ray Chen. Chairman, if you do that, you will have to give more ample time to us. Well, if you're only giving us 3 rounds separately, then there should be 6 rounds out if we are putting these 2 clauses together. I understand. Please go through these 2 clauses now. Thank you, Chairman. Part 3, protection of national anthem, which is clause 6 to clause 8. So these include offense of misuse of national anthem or offense of insulting behavior. Let us first go through clause 6. Clause 6 is in relation with clause 8 of the bill. So this is the misuse of the national anthem, lyrics or score of the national anthem. 6(1) points out that national anthem or lyrics or score of the national anthem must not be used in A, trademark or commercial advertisement, B, private funeral event, or C, on an occasion at a place or for a purpose prescribed under subsection 5. 6(2) the national anthem must not be used as background music in a public place. 6(3) a person commits an offense if the person, without reasonable excuse, uses the national anthem or the lyrics or score of the national anthem in contravention of subsection (1) or 2. 6(4) A states the offense. A person who commits an offense under subsection 3 is liable on conviction for a contravention of subsection 1A to a fine at level 5, which is $50,000, or otherwise to a fine at level 2, which is 5,000 Hong Kong dollars. 6(5) the Chief Executive and Council may, by notice published in the Gazette, prescribe an occasion, place, or purpose for the purposes of subsection 1C. And 6(6) defines public place. Now I would like to move on to clause 8 as suggested by the chairman. Clause 8. Music, words, or score to be regarded as national anthem or its lyrics or its score. So, a piece of music, whether or not including words intended to be sung or spoken with music, is to be regarded as the national anthem if the piece of music so closely resembles the national anthem as to lead to the reasonable belief that the piece of music is the national anthem or part of the national anthem. And then the words are to be regarded as the lyrics of the national anthem if the words so closely resemble the lyrics, and C is supposed to be regarded as the score if the score so closely resembles the score of the national anthem. Mr. Onokim, thank you. Well, 7 talks about insulting behavior, and Clause 8 talks about music, words, or score to be regarded as national anthem or its lyrics or its score. And then it defines music, words, or score. And actually, these are very different concepts. Do you have to put these two together? No, we're actually looking at Clause 6 and 8 and not 7 and 8. Oh, this is Part 3. Can we deal with this separately? Well, yes, we are talking about Clause 6 and 8 of Part 3 because Clause 6 talks about offense of misuse of national anthem, and 8 is on the definition of music, words, or score. Well, I'm talking about 7, 8 here. I haven't talked about 6. 6 is the offense of misuse of national anthem. I mean that there is a difference in nature for these 3 clauses. Well, yes, I have considered your view, and I have discussed with the legal advisor how we could better discuss Clause 6. Because Clause 6, when we talk about Clause 6, then of course we will need to refer to Clause 8. Because 8 talks about the music, words, or score. Mr. Ray Chen. Well, I said if 6, 8, you're putting this together, I agree with you that when we talk about 6, then we're going to touch on 8. Well, I mean, we can talk about 6 and 8 together. So when we move on to Clause 7, can you also allow us to talk about 7 and 8 together? Because of course you would refer to Clause 8 when you talk about Clause 7. Now, of course, it's best if you can can discuss these 3 together, but I don't want to do it this way. So we first deal with Clause 6 and 8. Mr. Elvin Young, first round, 4 minutes. Thank you, Chairman. Clause 6, bracket 2 states that the national anthem must not be used as background music in a public place, and Clause 8 defines that when a piece of music closely resembles a national anthem as to lead to the reasonable belief that a piece of music is a national anthem. Does that mean that when any shops, restaurants, or bars play some music similar to the national anthem, such as 求文求粵記, then that would be in violation of the bill? Well, P.S. First of all, we have to see whether it closely resembles the national anthem. If it's not, then I'm not sure whether you're familiar with 求迷奇遇記, but this song is actually an example used by many people. So it is a song, well, you don't have to worry about. So but I'm not sure whether you could help us. 求迷奇遇記 has it actually fallen into Clause 8? This is a song by Hacken Lee. Have you heard this song before, P.S.? Oh, yes, I have. Well, Clause 8 Well, let's say this if you put this in court, then well, this has to lead to the reasonable belief that the piece of music is the national anthem. Well, if you ask me personally, I don't think that this song resembles the national anthem. Well, I am going to also ask about this. I think the administration should first listen to this song, or maybe a song by Leon Lai on All Day Love, because this can really help us. Well, I'm not going to just target on one song now. I would like you to help us to explain whether you could give us any example on 6 bracket 3. Well, the secretary and our team have discussed these two songs thoroughly. Perhaps we could explain this further at the next meeting. Well, for without reasonable excuse, I would defer to Mr. Pang. Thank you, Chairman. Well, the court will consider whether there is a reasonable excuse, and of course each case should be viewed individually. There has not been any interpretation of these words without reasonable excuse. So this would ensure that the court decision would be fair. Well, Mr. Pang's is stating facts, but then do you have any example to help us understand that whether there could any examples that you could show us? When we draft the bill, we hope that it could comply with the spirit of the basic law. We cannot rule out the possibility that some people contravenes this clause unintentionally. There are around 1,000 cases in which without reasonable excuse has been used in defense. It's Mr. Gary Van's turn now. We are going to adjourn the meeting after he asks his question. All right, I would like to ask about the misuse of national anthem. So 6(1) bracket C said that it cannot be used as a trademark or private event, and it cannot be used as background music in a public place. So the East Asian Games are not an occasion in which the national anthem should be played under Clause 5. But my understanding is that many large sporting events are held in public places. I'm not now talking about Schedule 3. And in these outdoor public places, the national anthem can be played. Would that contravene the national anthem being used as background music in a public place? How do you understand 6 bracket 2 when some events play the national anthem? Chairman, we believe that the sports federations would not play the national anthem many times. They might just play it in the beginning. We don't want it to be used as background music. We didn't put in a footnote here because if we should interpret background music as repeating the song again and again. So it needs to be continuous. to be defined as background music, so there is no legal definition. Well, no, I'm talking about common knowledge that background music would be played continuously. So the court will need to judge this with common sense, because there is no statute law on the interpretation of background music. Well, my understanding is that it's called background music because it has nothing to do with a theme and it is played continuously. I mean, this is how people in general understand background music. I'll have follow-up, but I'll ask it next time. I'll now close the meeting. The next meeting is on Saturday at 8:45 in the morning. I now close the meeting.